signal? I don't know. I was told to gesture for the live stream, so consider this a verbal gesture. All right. Great. Well, I have the unenviable task of empaneling the 5 p.m. on Friday panel, which is always has more viewers online than in person. And we've always wondered, how do we solve this problem? And I think from the last panel, we now have a solution, which is the panel should be about corporate law. And then everyone will stay with rapt attention, and there will be fireworks, and it'll be a lot of fun. But this panel is not quite that exciting for most people. It is about the future of administrative statutes and administrative interpretation. I think we settled on that means, Loper Bright, major questions doctrine, maybe a dash of non-delegation. What does the future look like? And the program is a little misleading because I'm not, this is a self-moderated panel, so I'm actually a participant. We are going to sort of self-moderate, and I'm going to take the lead here, but I'm also going to participate. So I'm Ilan, I'm at the University of Minnesota. I'm going to say about, we're each going to go for about 10 minutes. I'll start us off on the topic, and then Eric Bolinder will go next. He is a new professor at Liberty University, and he actually litigated the Loper Bright case in the DC circuit. So very excited to hear his experience and what he has to say about that. Then we're going to hear from Brian Slocum, who is a very prolific scholar at Florida State University. He is the Stearns Weaver Miller Professor of Law, writes about statutory interpretation, legislation. And then last but certainly not least, Tara Grove, who is the Vinson and Elkins Chair in Law at the University of Texas, also a renowned teacher and scholar of federal courts and statutory interpretation. So that's where we're going, and I'll kick us off. Does someone want to keep? I'll keep my own time. I'm going to be a good role model here, and I'm going to stick under the time. Okay. So I want to do two things with my, I promise, short time. First, I want to defend the proposition that Loper Bright should have been a 9-0 opinion, at least as far as I have been able best to understand the majority and dissenting opinions and what that means for the future of deference to agency. I'll call it decision-making, since we don't quite know what to call it at this point. Second, I will briefly defend a continued role for the major questions doctrine in a post-Loper Bright world. My aim is to say something that triggers each one of my co-panelists before their remarks. Okay, so starting with the Loper Bright case, overturning Chevron deference. My claim is that very little, almost nothing, dare I say, separates the best reading of the majority's opinion in that case from the best reading of Justice Kagan's dissent, at least if that dissent is read in light of Justice Kagan's prior opinion in Kaiser. So Kagan describes Chevron step 1 as follows. The inquiry at the interpretive step, she says, is rigorous. I'm quoting now. A court must exhaust all the traditional tools of statutory construction to divine statutory meaning. But sometimes after all those tools are deployed, she says, the statute remains ambiguous. And it's important to understand what she means by ambiguous. She told us in Kaiser, and I quote, first and foremost, a court should not afford deference unless the regulation is genuinely ambiguous. The core theory of deference is that sometimes the law runs out and policy-laden choice is what is left over. So the bottom line, Chevron step 1 should be rigorous, but sometimes the law just runs out. Okay, let me now say two things about all of this. First, her description of Chevron would be unrecognizable to most practitioners in the circuit courts. I'm stepping on it maybe a little bit. We'll see what Eric says about this, but take the DC Circuit decision in the Loper Bright case itself, which I think is representative. The majority concluded that the statute was not wholly unambiguous. There was still some question as to the statute's meaning. Is that a rigorous inquiry? I'll let Eric say more about this if he's so inclined. Point being, Justice Kagan's description of step 1 is unrecognizable. Okay. But let's take her at her word. If courts genuinely deployed a rigorous step 1, then I'm not sure the majority would disagree with anything else Justice Kagan wrote in her opinion. She explained that sometimes the law just runs out. But if the law has run out, what are we interpreting? Kagan is quite right that all that would be left over is policymaking, gap filling. That is what the majority opinion also says. The majority, channeling the late giant of the field, Henry Monahan, writes that sometimes the best reading of a statute is that it delegates policy-making discretion to the agency. So it seems to me that the dissent is saying courts should rigorously construe statutes, but sometimes the law runs out, leaving policy-making discretion to the agency. And it seems to me that the majority is saying courts should rigorously construe statutes, but sometimes the law runs out, leaving policy-making discretion to agencies. Yes, I repeat myself. How is this not a 9-0 decision? Okay, let me now say something about the major questions doctrine, which is the other statutory interpretation development, depends who you ask, in the last few years. So I'll be particularly brief here because I have written at length about this in a paper, and Justice Barrett adopted a similar version of the argument that I have sort of adopted in her Biden v. Nebraska concurrence. So naturally, I think her concurrence should have been also 9-0. Let me begin by suggesting that the linguistic account, which is the account she defends and that I defend, right, that the major questions doctrine is not actually best understood as a substantive canon, that it's actually a linguistic canon, and a defensible one at that, consistent with textualism. And that's the claim. But let me start by saying that the linguistic account accurately reflects the court's major questions cases, despite some of the justice's rhetoric. Like, I admit some of it sounds a bit inconsistent. Let's just look at West Virginia v. EPA. The court said we are sometimes, quote, reluctant to read into ambiguous statutory text, an extraordinary delegation claim to be lurking there. The word system in that case, by the way, national energy system, was at least ambiguous, the best technological system of emissions reduction. It could mean a system within a plant, which I think was the most obvious meaning, or it could mean a national energy system. The point I'm trying to make here is that I don't think this is a substantive canon, or at least it doesn't have to be interpreted as one. It's just a tool for resolving ambiguities. There's a threshold. The statute has to be ambiguous, which is not quite how clear statement rules as the substantive canons work. Clear statement rules work even if the language is otherwise unambiguous. I don't think that's how this doctrine has been deployed. Okay. Now, if that's true, if the doctrine indeed requires this threshold of ambiguity and is about resolving those ambiguities, then I think it's consistent with textualism. If textualists resolve ambiguities by trying to ascertain which of multiple possible meanings the legislature likely intended, then I think this version of the major questions doctrine accurately accounts for the legislative process, as far as we know anyway. It's true that Congress often delegates tough policy questions. That's public choice theory 101. It's also true that legislators often engage in deliberate or strategic ambiguity. I suppose that's public choice theory 201. But the question is whether legislators are likely to delegate the resolution of tough questions through ambiguity, through oblique language. That's the question, and as far as I know, there's only been one empirical study truly bearing on this, and in that study, Professors Gluck and Bressman find that the congressional legislators and drafters do not typically intend to delegate major authorities, major policymaking questions through ambiguities in language. Okay. Now, suppose textualists instead resolve ambiguities by trying to ascertain which of multiple possible meanings an ordinary reader would understand. Well, ordinarily, the recipient of a delegation or of information who is sensitive to the stakes at issue is likely to demand more clarity the higher the stakes. Now, Professor Dorfler has written about this, and I took most of my inspiration from his paper called High Stakes Interpretation. I think it's correct. I know Brian on this panel and some co-authors have conducted additional empirical work that tries to call this into question. I'm not sure that they succeeded in that, and so I'll let Brian defend it. If he's inclined, he can talk about whatever he wants just on this panel. Okay. Now, to be sure, all of that also raises the question of what is the high-stakes outcome, invalidating the agency action or the agency action itself. Fair enough, fair enough. But I submit that the question the judge has to answer is the meaning of the statute, and so the likely consequences of the delegations are what must be considered. Okay, last point that I want to make is that there's historical support for the common sense intuition that is the major questions doctrine. In early debates over the necessary and proper clause, there was a question whether incorporating a national bank was too great an important power to be left to implication. Everybody in the debate agreed that some authorities, like the power to tax or to declare war, were too important to be left to implication. Madison summarized the point. In admitting or rejecting a constructive authority, not only the degree of incidentality to an express authority is to be regarded, but the degree of its importance also. since on this will depend the probability or improbability of its being left to construction. The intuition also exists today in agency law. Here's the third restatement. A reasonable agent should consider whether the principal intended to authorize the commission of collateral acts fraught with major legal implications for the principal. Some things, in other words, just matter too much to be left to guesswork. It's the exact same intuition that we find in the major questions doctrine, and I'll stop my defense there at sub 8 minutes, just so everyone's aware. Thank you.
Thank you so much, Ilan, and thank you so much to the Federalist Society for inviting me. Like Ilan said, I was involved with the Loper Bright case, and I want to give you, because I think it dovetails on one of Ilan's points, I want to give you a little bit of the facts of the case, because that's not talked about a lot. I'm going to defend the court's holding, but I want to speak more about the future implications of what the court did here and what I think is going to happen next with the implementation of Loper Bright in the lower courts. And I particularly want to push back on the sentiment that's become popular lately that Loper Bright didn't change much in what's going on. So I want to push back on that a little bit. You say, well, of course, you want Loper Bright to mean something. You're involved. Yes, fair enough. But I think I have a good argument behind it. First, I want to talk about Loper Bright. It's a group of fishermen in the herring fishery, and I have a herring tie clip on today to accentuate that. It's a group of small businessmen, and the statute says that they could put monitors on their boats to watch them fish. The statute says that. I concede that. It gives the NOAA the authority, the discretionary authority, to require monitors on the boat. The statute says nothing about the fishermen being required to pay the salary of the monitors, at least in this fishery. But in other fisheries, 3 other specific fisheries, Congress gave NOAA, in the same statutory enactment, by the way, that created this authority to mandate observer coverage, or mandate the human observer on their boat. In 3 other fisheries, one of the richest fisheries, the Pacific fishery, we're all here looking at it, limited access privilege programs, which gives fishermen special benefits to participate, and the foreign fishery, obviously dealing with non-American fishing boats. It does give the authority to shift the monitoring costs of those industries. Not only does it give the authority, it caps the percentage of what people have to pay, even in the rich fishery, right, the Pacific fishery. And so I felt like this was a fairly straightforward statutory interpretation case. We have an implied authority that NOAA is claiming under this authority to carry monitors and also a necessary and appropriate clause. And then we have a specific delegation of this authority 3 other places in the exact same statute. And if Congress thought it had given this broad implied authority, well, then why did it delegate elsewhere, right? And you can think of all the statutory tools like expressio unius or the specific governs the general that we might want to use here. But at the district court level and the appellate court level, the agency said, well, you need to defer to us, the experts. This is not a question of scientific expertise, of whether or not a certain catch quota should be implemented on fishermen. This is a question of whether they have statutory authority to do this. And who is more expert at that? A bureaucrat at NOAA, who, yes, might be involved in the science, or a federal district judge, right? And I would submit that a judge is far more expert than someone who's working in NOAA at interpreting the bounds of the statute, right? But the court found ambiguity here. Actually, the district court ruled on step 1 of Chevron, which I still struggle to get on board with against us, but the DC Circuit found ambiguity and went to step 2. And that's why I think we talk about a lot of these issues. I'm going to get back to some major questions in a second. You can't miss the people that are involved. And coming out of practice for 10 years, it's very difficult to explain to a client who is a small business owner who's seeking pro bono counsel, who's up against the most powerful litigating entity in the world. I don't think that's an exaggeration. Oh, by the way, in addition to all of that resource imbalance, there's a thumb on the scale in the courtroom when we go in. Just be prepared for that. And I think that is offensive to the average American. Now, I'm not saying that's why the court should rule one way or another, but when we have these conversations, we shouldn't miss this real-world impact. We talk about large industry, but also think about small industry and small businesses who might be able to scrape enough money together to litigate if they band together. But are they going to do that if if an attorney's counseling them? Well, they're going to get deference anyways, which is why I think this decision is important. So let me move to my next point, pushing back on the idea that Chevron or that Loper Bright is a modest course correction. So first thing I'll say is, even if I do concede it's a modest course correction, if I and my small business plaintiffs are on a boat that's going straight into the rocks, and I have a modest course correction to the left of the rocks, right, even if you can see that here in this case on remand, which hasn't been decided yet, I'm very happy for that modest course correction because my case is not collapsing on the rocks of Chevron deference, right? But I think it's more than a modest course correction. I think, first of all, if you look at the empirical evidence that Kent Barnett and Chris Walker have put together in papers, talking about the high percentage of cases that got to step 2, and I think the government, I'm looking at right here, 93.8% of the time prevailed on step 2 when it got there. I think it's very difficult to wrangle, to grapple with that empirical evidence and say that there won't be some sort of substantive impact on the outcome of cases. Now, it might be hard, Cass Sunstein has a paper on this, it might be hard to evaluate that because it will probably result in more cases being brought, right, because people have a better chance, and agencies might also tamp down on some regulations, so it might be hard to do an empirical study on that, but I think if we look at it over the next 5-10 years, you're going to see some evidence of that. So one of the primary contentions against Loper Bright mattering comes from Adrian Vermeule. He wrote a paper on this where he says, well, it's not, it's just Loper Bright delegation. It's no longer Chevron deference. And a lot of people have keyed on a paragraph in the decision that says, well, of course, agencies can be given policy discretion and a broad, express delegation. And therefore, they have discretion in that and we should defer to them, right? First thing I'll submit is that, and I have some cases here that evidence that, not everything is a clear express delegation, right? If only Congress were to speak so clearly to say that you may have 10 scrubbers on a smokestack between 1 and 10, and the EPA may decide whether you have between 1 and 10 in their sole discretion, right? That's a clear express delegation. Some of those exist, not for the most part. So I think we need to look at these cases through 2 different lenses. One are ones that have implied delegations of authority, and Loper Bright, in a case I'm about to talk about, certainly fit that, and others that have expressed delegations of authority where they create some bounds. And the reason why I think Vermeule's argument falls short is because before we were deferring to the agency on what the bounds of their authority was, right? If I can set the limits of the broad express delegation of authority I have, because the court is going to defer to me on the interpretation of the statute, then I'm going to set them as broad as I can, and certainly to accomplish whatever my goal might be. So by courts now engaging to set those limits, I think that is a very significant change. I don't think that's a modest course correction. And of course, there will always be cases that will be difficult on that. But I think in a lot of cases it will matter. So let me tell you about one of the cases. It just came out of the Sixth Circuit. It's called Moctezuma-Reyes v. Garland, and it's from Judge Thapar. It's a pretty run-of-the-mill immigration case. The Board of Immigration Appeals heard an appeal from someone who was going to be deported, that he shouldn't be deported because he had an exceptional and extremely unusual hardship. And that's the statutory term. So in the past, the BIA, the courts would defer to that. Well, Judge Thapar pulls this case in the Sixth Circuit, and this just came out, I think, December 23rd, so this is a very new case. And he says, here's how I'm looking at applying Loper Bright. First, he creates, and please don't faint, a 3-step approach, which is 1, we need to independently determine the scope of Congress's authority to the agency. Independently determine the scope of Congress's delegation of authority to the agency. That is different. Before Loper Bright was decided, the courts would not be independently determining that, right? Unless they would say, oh, well, it's a clear statutory language, we can rule on step 1. Well, if they couldn't rule on step 1 in Loper Bright, and this was evidence all across the circuit courts, they were getting to step 2 all the time, whenever they wanted to, regardless of whether the Supreme Court was doing it or not. The second thing that Judge Thapar says we should do is ensure the delegation doesn't violate the Constitution. And I'm going to get to that if I have time in a moment. Obviously, he's talking about, is it too broad of a delegation that might invoke the non-delegation doctrine? And third, we determine whether the agency's interpretation stays within the scope of the delegation. So we create a bound. Is this bound constitutionally permissible? And were you within this bound? Right? And I think Judge Thapar has been reading, perhaps, some of the literature saying Loper Bright doesn't matter. And he says broad language, let me start first. He says express language conferring discretion to the agency is critical. So Congress needs to be clear. If they use the term reasonable, appropriate, and the agency has to find these standards to be met, and we need to defer to the agency when they define these. That's one thing if Congress is clear. But if Congress is unclear, which they are in these statutes, right? They don't say, I shouldn't say unclear. If Congress has not given this express delegation to the agency, then who defines what the statute means, right? Of course, it's the judge. So he said, if broad language alone triggered deference, we'd unwittingly return to construing less than precise words as implicit delegations to the agency that warrant deference. This can't be right. The case that declared Chevron is overruled did not quietly reinstitute it, right? So he's saying, we look at 2 different types of statutes, an express delegation that says the agency shall have discretion to define what this term means or execute some sort of policy. And then we have implied delegations like the one here that says no such thing. And so what he does is he empties the interpretive toolkit, to use the phrase, goes to the dictionary, goes to ordinary public meeting, does a lot of work to determine what exceptional and extremely unusual hardship means. Now, he ends up at the same thing that BAA thought with in the first place, but he rejects saying, I found they're on deference. They just happen to get it right. And this cuts off a future administration vacillating back and forth. And I'll just briefly mention one more case, which is the net neutrality case. So in the net neutrality case that just came out of the Sixth Circuit, right, dealing with the open internet order, if a case ever called for invocation of the major questions doctrine, perhaps it was that case. Net neutrality is pervasive, affects virtually every American, billions, trillions, I can't do math, right, in economic impact in regulating the internet. It is a major political question, but does the Sixth Circuit use the major questions doctrine in deciding this case? No, it does not. It says because with Loper Bright, we can just look at the statutory interpretation, we don't need to invoke the major questions doctrine. It specifically decides not to invoke it and says we can just deal with the statutory interpretation and empty our toolkit and show all of our work and how we use the canons. It's in public view, it's open to appeal, and therefore the major questions doctrine is not necessary here, which raises the question to me, I'd be curious what my fellow panelists think, is when is the major questions doctrine going to come into play, right? Is it going to be a tiebreaker when there are only very vague statutory terms that the court is just cannot figure it out, right? Or is the major questions doctrine not going to be used as much as it was before? And one gripe I have with the major questions doctrine is I don't think it went far enough. So I think about, in our case, right, in Loper Bright, perhaps it wasn't a major question of political and economic significance to the American people, but it was a major question of political and economic significance to the fishermen and the community of the fishermen. It was also an extraordinary regulatory authority to say that you have to carry a monitor and you have to pay that person's salary. And I would question why not extend it to there. I mean, Congress was legislating specifically on this issue and was giving an extraordinary and broad power. Wouldn't they need to do it expressly? Why should we limit this only to the big cases and not to the cases that affect other people? And so I have a couple concerns going forward with congressional incentives. So first, I think we can't forget Congress. We're talking about the executive branch and how it interprets statutes. We're talking about the courts, how the executive branch, how it construes statutes, and the courts and how they interpret it. Well, it's on Congress to be clear. And if in a sense Congress is becoming so unclear that courts, despite emptying the entire interpretive toolkit, cannot determine the meaning of a statute, particularly if it's a criminal statute, perhaps we need to consider that it's void for vagueness. I think that could apply to some of the civil statutes too, with civil penalties. And also, if Congress has spoken so vaguely that the agency has such broad power, then perhaps I think the non-delegation doctrine necessarily needs to come into play. And here's a concern I have, is that Congress will do one of two things. Either it will start giving incredibly express broad delegations, because they don't want it to fall on them, right? I feel like the incentives were all the wrong way. They don't want their name on anything they have to do. Let's make the agency do it. I can yell at them or I can celebrate what they've done. Doesn't matter, I get to go back to Washington. So they'll start doing insanely broad delegations. I'm saying hypothetically, if this were to happen. The EPA may decide how to regulate coal. And it's and we expressly give them broad deference to do whatever they want, et cetera, et cetera. The other thing Congress may do is amend, I don't think they're going to amend the APA, but they could change agency organic statutes to implement some sort of deferential review to agency action. And I think if the Supreme Court wants Loper Bright to mean something and wants it to be a lasting doctrine, if Congress, and I'm not saying it will, but if Congress starts misbehaving this way, then it is a necessity that the major questions doctrine needs to be invoked by the Supreme Court, needs to be revived by the Supreme Court. The non-delegation doctrine, needs to be revived by the Supreme Court. So I'm probably over time, but I appreciate hearing from the rest of the panelists.
That's great. Thank you, Brian.
Okay. I'm going to resist Ilan's provocation to get into babysitter hypotheticals, at least for a little while, because I wanted to talk about Chevron and Loper Bright, which I guess my thesis is that I might agree with Loper Bright. I guess I'm kind of in the middle, so I'm kind of in the middle. Depending on how the court and lower courts in the future conceive and build out the doctrine. Because I do agree that Chevron was problematic in various ways, and not because agencies received discretion, but more so the way that the two-step doctrine was constructed. So I think Chevron is interesting because I really think it's true and it's kind of major point about interpretation, and that interpretation involves policymaking, at least at some points, and that's really this kind of truism of legal realism. But on the other hand, I agree with Ilan that Loper Bright, in a sense, is also very straightforward, right? If you accept Marbury v. Madison, you have to accept the idea that the judicial branch decides what the law means, which I really don't think Chevron ever kind of was in tension with that, but we can probably all agree with that principle. And also the point that the court made that outside of the administrative context, courts never kind of run out. And this is the kind of difficulty of Chevron, this idea that at some point in the interpretive process, courts run out of tools to use and they just have to throw up their hands. And that was always a very awkward kind of aspect of Chevron, at least in the way that some people read Chevron. And so that point that the court made in Loper Bright repeatedly, I think, that the judiciary does just fine outside of the administrative context in interpreting statutes, and that courts aren't really hampered by ambiguity, right? Even though some statutes might be ambiguous, and kind of using that term broadly, courts can still reach the best meaning of the statute, right? They can still interpret it according to its best meaning, which is obviously true. And that's why I think Chevron was always somewhat awkward, and which was good for law professors, right? Because it created careers for many law professors over the decades, right? And two aspects of Chevron, I think, were particularly problematic and create, I think, a new opportunity for the court now with Loper Bright. And one was this across at least how it initially started out in Justice Scalia's at least initial conception of Chevron that he argued for in Meade, et cetera, this idea that there was this across-the-board presumption that ambiguity means delegation and calls for deference to an agency. That was always problematic, right? It was just this kind of broad fiction that the court eventually learned was kind of unworkable, and it needed to be made more sophisticated. And maybe, and probably a lot of people would agree, maybe that the court did so through Meade, et cetera, in a kind of maybe arbitrary way that wasn't always well thought out. And then the second part of Chevron that I think was particularly problematic was centering this idea of ambiguity, kind of what I mentioned before, this idea that deference to agency interpretations turns on this kind of linguistic notion of ambiguity, which is especially problematic because interpretation is holistic, and so courts combine kind of what linguists would call ambiguity identification with disambiguation. And so you had this kind of weird process where it was really arbitrary when courts would decide that there's ambiguity. Is it when we can't disambiguate? Is it when we think there's maybe one interpretation that's slightly better than the other? Is that still ambiguous? It ended up being arbitrary, even though agencies under Chevron, the win percentage went up, right? But maybe in a kind of arbitrary way. But I think with Loper Bright, it'll be interesting how the doctrine is kind of fleshed out in the future, right? So the court mentioned or seemed to indicate that Skidmore is still relevant, right? But exactly what does that mean? And there's also this tension in the administrative context, especially, which Justice Gorsuch noted somewhat in oral argument. He indicated that Chevron was a cure for textualist interpretation. And it goes back to this kind of idea of legal realism that interpretation involves policy making, but textualism is supposed to reject that idea, right? And so Chevron really, I think, kind of set up a pro-textualist kind of two-step process, not workable, I think. But I think the court will have to think about, in a way that's more sophisticated than Skidmore, about how, maybe we don't want to call it deference, but in what situations should courts especially respect agency interpretations? And I would, how am I doing on top of the way? You're good, 6.5 minutes. Okay. And I would argue that the court should maybe think about some arguments and some cases that maybe came after Chevron, but ideas that also preceded it. Like in there was a case in 1987 that kind of was controversial at the time. Justice Scalia wrote a scathing dissenting opinion, but it was INS v. Cardozo-Fonseca. I don't know if anybody remembers that case. Okay, one person. All right, I knew Mark did. So the court referenced pure, and Justice Stevens and Justice Scalia did not like the court's reference to a pure question of statutory construction. So the court said a pure question of statutory construction is for the courts, but these kind of as-applied interpretations that agencies make should maybe receive deference. And I think the court, and of course that raises a question of what is a pure question of statutory construction versus something that's applied. Sunstein and Slocum they wrote an article before Loper Bright was decided, and they made a distinction between interpretation and construction, which is kind of somewhat similar concepts. But I think the court should think about what judges and what the judiciary does best, which in my view, a pure question of statutory construction involves, like what happened in Cardozo-Fonseca. You have two provisions that maybe conflict and that need to be reconciled. That's what courts do. In contrast, what do agencies do best and what is really kind of discretionary about interpretation? And I would argue that it involves semantic meaning, and especially the semantic meaning of broad terms, which the court did gesture to in Loper Bright when it talked about, which I might have a disagreement, when the court talked about implicit delegation. So the court used a couple of examples, reasonable and appropriate, and I think scholars are wondering whether those kind of exhaust the universe of kind of indications that there's implicit delegation to agencies, and I would argue that they don't, that most, if not all words have a degree in it, a degree of indeterminacy, and words like reasonable and appropriate might have a very high degree of indeterminacy, but other words also have, most words have some degree of indeterminacy. And I think in those situations, it's appropriate to let the agency flesh out what the words mean within the context of the statute using their expertise in policymaking. But that's just one idea of that I think the courts will have to figure out necessarily to avoid textualist judges being non-textualist. Great. I'll talk about maybe we can get into the babysitter thing later. I don't know.
I'm happy to have that fight. Tara.
Yes, so thanks so much for being here. Thanks to Ilan for putting this together. I'm just going to offer a few thoughts. I think when you look at the language of the Administrative Procedure Act, you can interpret it in different ways, right? Like it can actually mean what the court says in Loper Bright, that courts have to decide questions of law in each case, or it can be what the court also says in Loper Bright, that actually the legal regime requires deference. And here I actually want to agree with Eric on one of his comments. I think Loper Bright's going to matter a whole lot, because what Chevron did was provide a rule of decision for the Supreme Court to guide lower courts. Okay, you see statute, turns out it's ambiguous, here's what you do, and here's what you do across the board. One thing that Peter Strauss pointed out about Chevron is that it was a rule of judicial administration. It made things clear what to do. It wasn't 100% clear. There's going to be disagreement about Chevron step 1, some disagreement, far less, at Chevron step 2, but it was a rule of judicial administration that applied across the board. Courts of appeals were actually pretty coherent in what they did. A study by Chris Walker and Kent Barnett showed that it actually helped make less ideological decisions in the lower courts. And Justice Scalia said in FCC versus City of Arlington, if you get rid of Chevron, we are going to have chaos in the lower courts. And that is what I anticipate. And I also anticipate, for people who are excited about the next administration, that there may be some regret about the destruction of Chevron, because there'll be far less deference from many judges. We have a very, very split federal judiciary right now about various things that the administration is going to do. So when you look at this from a judicial administration standpoint, if you care about consistency across courts, it's a little bit of a disaster. But I agree that the actual legal question is very difficult. Now, on the language in Loper Bright that leads people to think it doesn't matter, it says, okay, well, if there's a delegation to an agency, the agency gets to kind of do stuff. This is where I think the major questions doctrine matters a tremendous amount, because the major question doctrine is going to give courts license to kind of say what are agencies allowed to do. There's been a lot of writing about the major questions doctrine, and some of the writing is whether the major questions doctrine is consistent with a textualist approach to interpretation. And one of the things that I've written is that there are different versions of textualism. And if you have kind of what I've called a more flexible version of textualism, it's more open to substantive canons and things like that, yeah, the major questions doctrine is probably consistent with that. That's not the version of textualism that I advocate. I advocate a more formal, restrictive version of textualism. But there are some versions of textualism with which the major questions doctrine is quite consistent. As Ilan knows, I disagree with him that more restrictive versions of textualism can be reconciled with the major questions doctrine, because I think it's just really hard to argue that the major questions doctrine is a linguistic canon as opposed to a substantive canon. I think Justice Gorsuch actually was quite upfront that this is a way of enforcing the non-delegation doctrine. I think that's a very honest approach. It's not really the text, right? It's rather a constitutional concern that's driving that. And there are versions of textualism with which that is totally consistent. But saying that, well, Congress just won't actually give big things over to agencies, that's a substantive claim, not a linguistic claim. I personally think Congress does and has for many decades given lots of things over to agencies. That's actually one of the reasons Loper Bright was litigated, right? People are very concerned about delegations to agencies. So if you look at our practice over the past 80 years of history or so on, it's really hard to say there's any kind of practice in the United States that limits what Congress gives over to agencies, which really undercuts the idea that there's some sort of a linguistic agreement that that's a bad thing to do. It's a substantive idea, a very reasonable one, one with which I don't share, but it is a substantive canon, and I think hard to reconcile with strict versions of textualism. I had a conversation with John Manning not too long ago, and he said, gosh, I really would like to write about the major questions doctrine. And I said, don't worry. You already did. So for those who are interested, I highly recommend John F. Manning, The Non-Delegation Doctrine as a Canon of Avoidance from 2000 in the Supreme Court Review. And this was a comment on FDA versus Brown and Williamson. And it is a beautiful critique, even in 2025, of the major questions doctrine from a textualist perspective, and I recommend it to you all. One of the things that John said in that paper was narrowing a statute in this way, in that case, the court held the FDA did not have the power to regulate tobacco. John says, narrowing a statute in this way threatens to unsettle the legislative choice implicit in adopting a broadly worded statute. John goes on to say, if the point of the non-delegation doctrine is to ensure that Congress makes important statutory policy, a strategy that requires the judiciary, in effect, to rewrite the terms of a duly enacted statute cannot be said to serve the interests of that doctrine, end quote. The final thing I want to say, and I'm not saying this as a provocation, I mean, this is a genuine curiosity for me, is why the change among members of this institution as to issues like Chevron. So if we circle back a couple of decades to 1990, to the 1980s and 1990s, members of the Federalist Society and the Heritage Foundation were among the biggest supporters of the Chevron doctrine. In fact, it was a doctrine created by the Reagan administration and lawyers in the Reagan administration, and was despised by progressives initially because of the way it handed power over to agencies controlled by the president. In 1992, the Heritage Journal Policy Review published an article seeking to distinguish Reagan-Bush judges versus their predecessors on the ground that, quote, Reagan-Bush judges tend to accord greater deference to the substantive decisions of expert agencies, quote, with Justice Scalia's commitment to Chevron as a leading example. So this is just a question I have. Why did the conservative legal movement give up on Chevron? And I'll stop there.
You don't have an answer?
I don't know. It's a genuine question.
Great, and we're making great time, so thank you to everybody. Do you want to start, Eric? And then I was triggered by some things I heard, even if I did not sufficiently trigger others to respond. But you want to start?
Yeah, I'll start with the question you asked at the end. I have a few points I want to make. I think if you read the Supreme Court's history of Chevron, right, they call it a dizzying breakdance, and how it's been implemented over time. Now, I was not a lawyer in the late 1980s, 1990s, so I think I'm off the hook. No.
Were you even alive?
Ish. But no, if you read the history of it, it just wasn't working. And that's why they had to layer on me. They had to layer on step one. They had to layer on step two. DC Circuit had step 1.5. I mean, there were all sorts of things that were, kind of coming in Chevron. I mean, when Chevron itself was first decided, I don't think the court really intended for it to be what it was. And true, it was Judge Walden and Judge Scalia, then Justice Scalia who did that. But I just think as they looked at it over time, it just wasn't working. It was delegating far too much authority to the executive branch, and you could see that it was frustrating what we view as originalism and textualism. And I think that takes me to my next point, which is talking about how there's policymaking inherent in statutory interpretation. Now, I'm not naive. I don't think that every judge is capable of being absolutely ideologically pure when interpreting a statute. But I do think, particularly if you look, and I have a few more cases, but if you look at the cases that have come out recently after Loper Bright, judges are at least showing a great extent of work in how they're doing statutory interpretation, what canons they're using, what they're relying on, whether they're relying on Skidmore or not. And a couple judges have said, well, Skidmore seems like it's an option the Supreme Court gave us, but they're not viewing it as something that's mandatory. It's more of a historical and contemporaneous canon that we can use if we think it's helpful. And so I would much rather have judges doing that statutory interpretation, using the statutory canons of construction and all of that, rather than having a bureaucrat in an agency doing it, being able to change their mind every 4 years. One of the arguments for Chevron is that it created uniformity. Well, of course it naturally created geographic uniformity, because every single court would simply defer to what that executive branch was doing. But then 4 years later, it would create another new geographic uniformity that went the other way. Look at Brand X. Look at the history that the Sixth Circuit lays out in the net neutrality decision. So the idea that it created uniformity was, well, it let the executive change what a statute means every 4 years. And it simply cannot be the case that what Congress intended when it first passed a statute changes magically every 4 years. It has to have a best meaning. And so I think, yes, I'm not naive. I'm not going to sit here and say, oh, judges certainly never, conservative or liberal, let their own policy views intrude on the way they interpret a statute. I mean, People are human. I get that. But I do think that if we're forcing this out in the open with statutory interpretation, with statutory construction, with a neutral arbiter between the executive branch and the Congress saying, executive branch, you're exceeding what the Congress delegated you, I think that is best in the hands of the judiciary, rather not in the hands of the bureaucracy. I think one other point on Skidmore, and I already kind of briefly made this, but I too wonder where Skidmore is going to come in, and I'm curious at looking at, for example, the Judge Thapar decision that I read from, the concurrence chastised him for not using Skidmore. And his view was, well, I didn't need to use it. The statutory meaning was very clear, and even if I did use it, I would get to the same extent. But he, at least, as far as I read his opinion, is not viewing the Supreme Court's suggestion of Skidmore as a mandate, but simply as, here is a useful tool that you may use. And real quick, Tara, I do agree with you in the major questions doctrine. I do think it's a half measure. I think it's a feint at the non-delegation doctrine. Now, I think they should have gone the whole way. But I do think it is hard to sustain it as a linguistic canon when you sort of go halfway there and stop, right? Because, conceding I know what Justice Barrett wrote, and now I've just triggered Ilan myself. But yeah, I've talked too long. I'm sorry.
No, that's great. Tara, can I take a stab at that last question? And then Brian, if bless you. In the 1980s, right, what was happening in the federal judiciary before this organization had the dramatic impact that it had over the 40 years? I think you had what can only be fairly labeled as judicial activism, judicial adventurism. And look at the Chevron decision itself, what the DC Circuit had held in that case, which is, they looked at the very super broad purposes of the statute and said, well, in non-attainment areas, you can't use the bubble policy, and in attainment areas, you can use the bubble. I mean, they were really just pulling this stuff out of thin air to thwart the policy, in that case, of the Reagan administration. And so it makes sense to say, if the judiciary is going to be that activist, well, let's grant that there are ambiguities. You're being a little too adventurous about finding ambiguities and resolving them as a judiciary. Defer to the choices of the executive branch, because ultimately they aren't always interpretive. Like, I thought Chevron actually involved policymaking. I think it was a gap that the statute didn't think about what happens when the definition of stationary source, when multiple definitions apply. You could have a facility with multiple structures or an installation with multiple buildings. I mean, right? And so I think it was sort of a policymaking question. Well, fast forward 4 years, and all of a sudden you have judges who, again, depends on your perspective, are no longer being adventurous, again, depends who you're talking to, and are trying to be, stricter textualists. And you had this executive adventurism that transpired as a result of the Chevron decision. And so in a way, you can see it as consistent, right? I mean, one story of consistency is Republicans had one institution at one time and another at another time, but another is that they really cared about, not having adventurism, activism in the courts or in the executive. And it just sort of modulated over time what was the greater concern. I have a lot more to say about elephants and mouse holes and Brown and Williamson and so on, but let me see if Brian wanted to chime in, and then Tara, I'll send it back to you as well if you had any.
Okay, I wasn't going to answer the last question, but I just had 2 points, one about Skidmore and then one about the major questions doctrine, but not babysitters.
There's still time.
Yeah, I guess I agree with Justice Scalia in his view on Skidmore. He kind of had very little respect for it, no pun intended. He kind of gave it the back of his hand, because it really isn't a coherent doctrine of deference. And the idea that, and I agree with Justice Scalia, that the idea that judges should think about the thoroughness of an agency's reasoning, and more importantly, how persuasive the agency's reasoning is, that's just litigation, right? The more persuasive argument wins, but that's not a doctrine, that's not any kind of coherent doctrine of deference. So I kind of agree with Justice Scalia that just kind of a narrow version of Skidmore is pretty worthless. So I'm not sure why, if a judge is admonished to consider a Skidmore or not, I'm not really sure why that would matter. other than maybe some kind of rhetorical threat that the judge should maybe consider the agency's interpretation more so than the judge normally would. I'm not sure. I mean, the factors that maybe are part of Skidmore, like agency consistency and contemporaneousness, maybe we can argue about the degree to which those are important and should matter. That's actually much more substantive than the kind of nonsense of persuasiveness and thoroughness. But I would also argue, like I was mentioning before, that we need a lot more than that to kind of guide judges into thinking about what kind of statutory structures call for particular respect to an agency's interpretation. The major questions doctrine, I guess Ilan might be surprised that I'm not as opposed to your view as you might think, putting the babysitter, I'll see if I can mention that a couple more times, to the side. But kind of at its core, I think, and you can think about statutory language in kind of two ways. One way is if it's really ambiguous, and if those cases really involved ambiguity, then the major questions doctrine, I would say, shouldn't be controversial at all, right? But I think, I really think in most of those situations, there's something slightly different going on, which is they all involve kind of this idea of broad statutory terms and contextual evidence that conflicted with just the broad statutory terms. And so it involved this kind of question of whether the broad statutory terms should be interpreted literally. And I'm not, I argue against literalism in kind of various different contexts. And so, and I think in a kind of a linguistic sense, non-literalism is often consistent with linguistic meaning and public meaning. And so I don't think it's all that, should be all that controversial that broad statutory language shouldn't be read literally when it conflicts with other provisions and other contextual evidence, other statutes, other provisions, et cetera. I do disagree to the extent that people view the major questions doctrine as some kind of clear statement rule. I think that would work against linguistic meaning and maybe policy and other things, but I guess we can argue about whether it's actually a clear statement rule or something different.
Tara, do you want to jump in and then?
Yeah, sure. So I really appreciate people taking my question seriously because I meant it as a serious question. And I appreciate Eric's response. You know, it's interesting, like the Reagan administration advocated Chevron so that it could change policy, right? That was the whole point, and it was considered not a bad thing, but democracy, right? The Reagan administration had been elected by a lot of people, and when a new administration comes in, they can also change things, and this is actually quite healthy in a democracy. And I also appreciate your response, Ilan, because it was extremely honest. But it also saddens me because it very much comports with the explanation that I've heard from people on the left, which is, well, conservatives didn't have the judges in the 1980s, and now they do. And that I don't want that to be a reason that we ever accept a legal principle or reject a legal principle. Leigh has accused me of being too much of a formalist, and I really am. But I think you should stick to your principles. I see this with state standing, with progressives loving state standing when there's a Republican in office, and conservatives loving state standing when there's a Democrat in office. I will say I'm consistent on state standing across administrations. I hate it most of the time. But you know, I find it really sad when people change their principles based on convenience rather than something much deeper and more profound.
So let me clarify something, because I certainly didn't intend to convey that. At the end, I sort of gestured at a possible story is the story that you hear among, you know, the left, is that they control the institutions and they were on the ins, they were on the outs, now they're on the ins. But the story I tried to tell before I said that as a possibility that people say is quite different, right? I think your principle can be that you think neither the executive branch nor the judiciary should be adventurous in its interpretation of the law. They should stick to a pretty, a textual interpretation, and that an activist judiciary in the 1980s was not doing that very well and hampering sort of the better interpretation of those among the executive branch, and that over 40 years it just flipped. Yeah, because it's true, Republicans prefer the interpretation, but there could be a principled reason that they do that, right? Because they think textualism is just intellectually the correct answer for whatever reason. But that brings me to another question for you, Tara, actually, which is, Brian at the end said he rejects literalism. And I was hoping you could say more about the variants of textualism that you described, because how is your formalist, strict textualism different than literalism, I guess is my question. And I'd like to seize on the Brown and Williamson example, because I don't know that John Manning is right about that, right? So it's true if you take a literal interpretation of the terms drug and drug delivery devices, it could include, nicotine, tobacco, cigarettes, and so on. But then you look at the rest of the statute, and it's like, wait a minute, if it really includes this, then the whole scheme doesn't work for cigarettes, because the whole point of the FDA is it approves drugs that are safe and effective for their intended therapeutic use, and cigarettes are never safe and effective, right? And so they would have to be misbranded, right? So the whole structure of the act would sort of fall apart, and then you look at it and you say it's ambiguous. It's ambiguous. And then one of the tools that, you don't need to use major questions at that point, by the way, but you could use elephants in mouse hole. You don't have to. It was a small part of the opinion in Brown and Williamson, right? But that all sounds like textualism to me, right? It doesn't sound like rewriting the legislative bargain. Scalia, of course, couldn't say that because he was hamstrung by the Chevron framework, so he had to stop it at step one. He had to say it was clear and unambiguous, when of course everybody knows it was ambiguous, and he was just advancing what he thought the best reading of the statute, right? But clear away the Chevron framework, and then just read his opinion without Chevron, Justice O'Connor, you clear away the Chevron language in that. And that's like a perfectly textual opinion, right? So what was wrong with that opinion, I guess, is another variant of the question to you.
Wow, so there's a lot there. So I've said in multiple articles that semantic context, overall structure is really important. I have an article about the use of judicial precedent just to help clarify meaning, which is something many textualists use, and I'm talking about use of judicial precedent to figure out the meaning of words, as well as dictionaries. So I can commend you to my assorted articles explaining why it's not literalism. On Brown and Williamson, it's interesting. I always thought it was a purposivist opinion. The way the court goes through the analogy, goes through the analysis, as John points out, they barely talk about the text, and I think it's important that it's an O'Connor opinion, right? It's not Scalia, although he signed on, and I think it's possible one could write a better opinion in Brown and Williamson, which is kind of what I hear you saying, sketching out a possible opinion, but that opinion was very light on text, very heavy on post-enactment legislative history, very heavy on purposivism and how it could not possibly make sense for the FDA to have that authority. And there's a lot to that, right? Like the FDA had not exercised that authority. Like from a purposivist perspective, Brown and Williamson makes a lot of sense, but I think the actual analysis there, and that may have something to do with the author, right, was not very textualist. And I think what we're seeing in debates over statutory interpretation and debates over textualism is, the reality that when you adopt a particular approach to interpretation, you're not always gonna like how it comes out. A case that for me is really, really hard is King versus Burwell, involving the Affordable Care Act, right? The challenge there would basically undermine the entire statute. That's a statute that I personally think does some good stuff. I'm maybe the only one in this room who thinks that. But I still, to this day, think Justice Scalia had it right in the interpretation. I don't like that result, but I think that's the correct textual result. That's what I thought while it was being litigated. That's what I thought after it came out. And, you know, I've had people try to explain to me how state can mean something different than what it appears to mean, but I think that's really hard. And, you know, what I think is that, like, there are times when my interpretive method is going to reach decisions that I don't like. I think that's how statutory interpretation should work. I think that is how law should work. And it disturbs me to no end when I see people always trying to kind of fudge the interpretation on the left and the right to get to the result that they want, rather than just acknowledging, hey, you know, my method actually leads to a place I wish it didn't.
We have about 28 minutes before you are allowed to have a drink. So we'll have some questions. Mike, go ahead.
Yeah, so I guess one comment and then one question. So it's complicated, I think, why Chevron declined on the right. As someone who's been on the right and always been against Chevron from the 1980s, maybe I'm a little bit in a different situation here. But first of all, I guess as was pointed out, you know, it wasn't just a Republican or a conservative position. Pat Wald was a very big proponent of Chevron in the DC Circuit. My understanding is that Bork pushed against it. So, you know, there was a kind of mix on all that. I think actually some of what's going on was just different understanding. You know, maybe it's too academic a view of it, but, you know, I think Aditya Bamzai's article was really important, showing the importance of the two canons. People had misunderstood that. They thought there was a history of deference that wasn't just general deference. There was also a misunderstanding on some people that these mandamus cases were deference cases as well. And just a sort of general formalism, I think, people kind of understanding that you know, words and meanings, and you didn't need deference to solve these, to decide these cases. You know, to some extent, Chevron had legal realist roots in it. So anyway, you don't even if you view Ilan's argument as being about political results, which I know Ilan doesn't. I don't think that's the only possible explanation. My question is, so prior to the APA, we had these cases, Gray versus Powell and Hurst, that were mixed question cases. And the court, Chief Justice Roberts mentions those mixed question cases. But then when he gets to saying what the new rule is, he kind of doesn't go into that. And it's just really a question, and I'm not sure really, I'm just curious, how people on the panel would predict. Do you think those mixed question cases will be thought to, you know, the Supreme Court, when it gets to it, will say, oh, mixed questions get deference? I don't think there's a right answer to that, in the sense that the opinion is kind of very much ambiguous. But I'd be curious to know what people think.
Initial reaction, or?
Well, I'm not sure what the court's going to say, but I think whether the court says something explicitly or it might not be explicit, but I think implicitly, I think the lower courts at least are going to give more deference to these mixed questions because as I think the dissenting justices pointed out, a lot of them involve really technical issues and really implicate agency expertise. And I think courts would really be putting themselves out on a ledge and be exposing themselves if they really took a strong role in deciding some of these issues of word meaning. And, interpretation's always resolvable. The court was right about that in Loper Bright, but that doesn't mean it should always be resolvable in the same way by courts. I mean, if you look at void for vagueness doctrine, which is kind of having a resurgence, right, on the Supreme Court, all of those statutes could be interpreted by the court. And you have kind of similar terms that have been interpreted by the courts, but instead the court has made a determination in those cases that the language is too general, right? Congress hasn't done its job. It's unlikely to do that in the administrative context, maybe for good reasons, but maybe the court, I think at least implicitly, is still going to have that same idea that maybe it's not for courts to resolve all these issues, and maybe agency policy choices. So instead of voiding the statute, it'll be instead a kind of a question of agency policy expertise. So I don't know if it's going to happen explicitly, but I'd be very surprised if it didn't happen implicitly.
Yeah, I'll say on the mixed questions, I agree with you. The court was a little bit unclear. It referenced Hearst and said, well, there it is, right? And then, and those are the difficult ones, right? And I think, context where it can come up, and maybe where Skidmore might be helpful. I'm not sure if I want to be defending Skidmore, but I'm gonna do it. Where it might be helpful is there's an assumption that the agency took a part in drafting the legislation. That's generally true, right? Anyone that's worked on the Hill knows that there's agency detailees that are there. And if perhaps there is some sort of contemporaneous and continuous interpretation of what some sort of very technical term means that perhaps Merriam-Webster is not helpful in defining, right? Judges can look to that to the extent it's persuasive. And I think on the questions of mixed fact and law, they don't always have the benefit of amici, but it's a time where, and I don't want to, the question is next, do we need to have some sort of regulatory Daubert? I'm not trying to go down that road. But where the court will take the agency's explanation of what the term should mean to the extent it's persuasive, just like Skidmore says, perhaps give it respect because the agency was presumed, right? And I think if you read in some of the court's opinions, it says this, to have taken part in interpreting the statute, and then consider what opposing counsel has to say. I mean, if the agency's interpretation is ridiculous, or if it will cause the agency to exceed the statutory bound that Congress clearly set, then the court could say, yes, we see Skidmore, but we're still going to go with what the amici, with what the individual says. But how that's going to play out, I think you're probably correct that in the lower courts, particularly on the, defining technical terms, that's how I think about it a lot of times, like what a real technical term means, or when someone does something unreasonable in a certain field or something like that, you are going to see that level of deference, and I think it'll probably be invoked through Skidmore. I just wonder as the cases percolate up, particularly to the Supreme Court, which I think should take a lot more of these, how they're going to approach it, and I'm not sure we know quite yet.
So if I can take a stab at this too, it's a great question, and I don't know what the answer is, but it strikes me, I don't want to sound too much like Justice Breyer here, but like this might be a spectrum, by which I mean, take some cases where, like the word system in West Virginia v. EPA, here are two possible meanings, and the statute actually resolves it. This is a system, the technological process in the plant. Okay, you might disagree with that, but there are certain terms that's the kind of inquiry where we can actually fix the meaning. Then there are things like reasonable, which is actually nobody disagrees on what reasonable means. Just everybody disagrees about what is in fact reasonable or not, right? So that is a delegation of policymaking authority to the agency. And it strikes me that the mixed questions that you're referring to, what is a producer? I think that was the great case. What is an employee? Or to take another example, Congress is actually much more specific when it talks about this, but like family and immigration context. Like we know certain things are obviously family, immediate nuclear family. We know things are not family, no marriage ties, no blood ties. Okay, what about first cousin, second cousin, third cousin? Okay, well, all of a sudden those terms, like employee, producer, family, will produce a set of results that clearly included and clearly excluded, or just included, excluded. It doesn't have to be clear. You could resolve that question with interpretation. And then there might be some space where between those two ends of precluded options and included options, there's a range of permissible policymaking choices, no different than a range of what's reasonable. It's just it's going to be much narrower in that range than if the delegation is do what's reasonable, right? And it's going to be much broader than if you have a word like system, or in my opinion, drug, but people disagree about that. So it just falls somewhere between those words, those terms, and the stuff of our and the stuff of State Farm that Kavanaugh described in his Kaiser concurrence, I would say. That's just my best guess at what they're going to do with it. And I'm happy to have a reaction from you.
I just wanted to thank you, Justice Breyer.
And I'll just say thank you for offering thoughts on the provocative question I posed, because that's very helpful. On the mixed questions, I anticipate very different answers from the lower courts, and this is what, as I said, Loper Bright invites, right? A lot of different approaches, and I suspect different courts of appeals are going to try to figure out different things to do. It's very much along the lines of what happened after Heller and McDonald in the lower courts, and I think there's a real question: how fast, how willing is the Supreme Court going to be to take up these cases again? There are lots of areas where I say, it would really help if the Supreme Court would take this up and provide some guidance. This may be an area where they're not going to be too keen to figure stuff out and kind of leave it to the lower courts. And so I think we're going to have kind of a cacophony of decisions.
And we shouldn't let Congress off the hook, right? I mean, to the extent that Congress is putting out these terms that are too vague and that courts are all over the place, I mean, perhaps Congress should legislate more clearly. And obviously, I'm probably a bit of an extremist up here that I think we should bring back the non-delegation doctrine and we should really hold Congress to what it should do. And I think the objection that you're probably going to hear is, well, how do you expect Congress to have all the technical expertise to do all these things to engage in it? And I think two responses is, one, I fully endorse increasing the budget and pay for congressional staff, bringing more folks in, helping, because anyone that's been on the Hill knows that everyone just cashes out and they take all that institutional knowledge with them. So I think Congress should expand that. Then the other answer is vertical federalism. It's a feature, not a bug, that the federal Congress wasn't meant to regulate the vast majority of things that impact everyone's individual lives. So perhaps Congress should get out of the game on some of those things if they're not able to be clear about what a term that can shift billions of dollars in an industry one way or another might mean.
Yes, sir.
Yeah, so Eric, you started out talking about the dilemma of small businesses confronting the awesome power of government, and fortunately, your client someone paid your salary, someone paid the cost to defend that client. Clearly, the client had some sort of outside support. And now we're talking about a lot of issues that are going to be litigated by very expensive lawyers as they clarify what did Loper mean. So let me suggest, the Equal Access to Justice Act was intended to, they use that exact same language to protect small businesses from the kind of government overreach that you exactly introduced your presentation with. And let me just suggest that a cleaner, quicker way to protect those very small businesses would be to strengthen the Equal Access to Justice Act so that it doesn't allow agencies to get out of the liability of paying for the attorney's fees and costs of defendants if they can show their underlying case was substantially justified, forcing the small business to relitigate the case. But if you just got rid of that and you had a clean rule, I mean, you could do a lot more justice for small businesses and reining in the bureaucracy. Talk about reining in the deep state by this kind of change without this kind of expensive litigation that's going to wind up back up the Supreme Court. I know that's a little bit of a soapbox, but that's something I'll run until 6 o'clock on a Friday. But
Soapboxes are permissible.
It's clean, it's done, and it's been hearings on the Hill to justify it, and it doesn't involve a lot of Supreme Court interpretations and everything else. It's changing 2 words.
Unless there's a reaction.
Oh, go ahead. No, I agree. As a former public interest litigator, I'd love for more fee shifting. Right. It would allow people to bring more cases. But yeah, no, I think it's a good suggestion.
Go ahead.
Mark Seidenfeld from Florida State University. I don't know. Maybe this is inappropriate. First of all, I'm not a Federalist and I'm not a textualist. And
nobody's perfect.
And well, I'm going to go even one further. In 1984, when Chevron came down, I was clerking for Judge Wald, and I've been a proponent of Chevron since. And I'm going to I was reacting to some of the reaction there. Maybe, I mean, it's a done deal, so maybe I shouldn't, but, you know, okay, first, was Chevron unworkable? Well, again, Walker and Barnett showed that it worked pretty well at the lower courts. There was some issues, but the Supreme Court, what bugged me about the case was they didn't even try to give guidance on most issues to the lower courts the way they did finally in Kaiser. So, for example, I know how I would do it. I'm not saying I'm the right way. But first of all, the Supreme Court in Meade set up a weakness in the Chevron doctrine by saying that it was based on congressional intent. Breyer and Scalia said that's a fiction, but it's a convenient one. But anytime you set up a fiction, you're inviting judges later to. There are other ways of justifying Chevron that are consistent with the APA Section 706, which is maybe it's a self-restraint rule by the justices themselves, right? They know that there are policy implications that are going to be influenced by ideology, and maybe if they're really kind of into the kind of notion that judges shouldn't get involved in that, they were constraining themselves and saying, look, we should defer to the agency because at some point, when we get to a point, where is that point? They could have given guidance on that. How clear does it have to be? Whatever theory of statutory interpretation you use, let's say you think, well, if I use that theory, there's a certain percentage that I'm right and a certain percentage I'm wrong. Maybe 55-45 is ambiguous, but maybe 90-10 is not. And now I'm putting numbers on there, but they gave no guidance on that except for Scalia, who said, look, if you think it's the best meaning, Judge, you should vote that and say that it's clear. I don't know if I agree with that, but at least there was a direction. And if the courts had done that, and then the one thing I did like about Loper Bright was it made clear that even after in those issues where there's discretion to the agency, after the court says, agency, you have the authority to do this, apply the arbitrary and capricious, I call it hard look test at step 2. That's the real constraint, I think, on agencies. That would have made a big difference in the workability and what happens at Chevron when agencies do Chevron. It's much more flexible. It gives the agency the chance to say what the policy implications are, but they got to do it, right? And the court never even approached that. So I think, and I've written about this, if you saw it as a rule of judicial self-restraint with a better defined step 1 and hard look review at step 2, I think it would have worked a lot better and avoided the question of because right now, you can say, well, judges do really well when there's no agency involved. Well, they have no choice. They've got to resolve the question. There's no agency involved, right? We don't know if that's good or bad, but when there are policy implications and you have the agency, why not rely on the branch that has more expertise, more political accountability? You might not think it's enough, but the courts certainly don't have enough. I mean, so, maybe I'm beating a dead horse here, but it seems to me that there are lots of ways that Chevron could have been modified that would have made it even more workable, even though I thought it was pretty workable.
Yeah, I have two responses. I think, to talk about workability of Chevron, think about Loper Bright itself. There's 2 cases. There's Loper Bright and Relentless. At the district court in Loper Bright, the district court judge ruled on step 1. At the D.C. Circuit, the court ruled on step 2. In the district court in Relentless, the district court ruled on step 2. And at the circuit court, the First Circuit said it was using Chevron, but would not tell you which step it was using. Right, and this is in one case with one issue. We have courts going every which way on it, right? Did they all come out to the same outcome? Sure, they all ruled in favor of the government. That's where they got, right? But I think, the case itself is a microcosm of what was happening across the lower courts and the fact that the Supreme Court disengaged from it. There was a case, a year or 2 before Loper Bright was decided, one of the Becerra cases, that split 5-4 on a really hard statutory interpretation issue, and the court didn't use Chevron. And if any case ever called out for it, was that. So I think the decades of experience showed that it was not working, and I think it was because judges were so eager to find ambiguity under a rock. And yes, it is true that Walker shows that the judges would rule for the government this vast percentage of time, but in that exercise of judicial humility, the judges were ceding the ground of statutory interpretation to another branch, to the executive branch. So yes, judges were being humble, but the executive branch was grabbing all sorts of power, and I think the growth of the administrative state, I don't think Chevron is the sole cause of it, but I think a lot of it can be traced to that. And I think the proof of how the administrative state has grown, and perhaps folks disagree on how big it should be, is because of the unworkability of Chevron and because it gave judges a really easy out. They didn't have to do the hard work. Let's just defer, get it over with, and move on to the next case.
Brian or Tara, do you have any reaction to that particular thing? I guess I would ask, because your colleague reminds, I guess I want to ask your colleague, but I clerked for a judge once who asked a question, and the litigant asked a question back at the judge. He said, "I'm the one who asked questions here. I don't want to make this mistake." But Justice Kagan's dissent in Loper Bright provides kind of the guidance that you're talking about. But my question is still, how is she saying anything different than the majority opinion? And I guess I haven't heard a persuasive answer to that question. And if it's not that different, I don't understand why the sky is falling because of this. It seems to me that they have provided the guidance, which is judges decide for themselves based on all the tools of statutory interpretation. And if you can count to 2 judges on a court of appeals for the proposition that the meaning is X, great. If you can count to 2 for the proposition that actually this is a permissible construction because it's a term like reasonable, or it's not within the, anyway, then that's your answer. Then you decide it's a policy-making question, like in Chevron itself, in my view. And I think that's fine. I think that's the guidance that you were looking for. I think the majority provided it. And if you don't think the majority provided it, I think Justice Kagan provided it. I just think she's saying the same thing, right? And I still haven't been convinced that she's not. But anyway, David, and then Leigh, and then we'll go drink.
I want to give a quick anecdote relative to that change between the 80s and 90s and the present. And my take on it, from just having some experience with conservative academia, was there really was simply a change in opinion because there was more information. One point at Boston College, some folks, Charles Kessler from Claremont, came and gave a talk explaining the rise of the administrative state, and explained in detail the history of ideas that informed the growth of administrative agencies, including non-delegation of powers, deference to them, et cetera. And one of the faculty members, who I would call sort of a core sort of mid-20th century Republican American, was indignant because he said, "I'd never heard this before." Okay? And what I take from that is I think there was a certain generation of Republicans, or just generation of Americans, after 1937, that are so steeped in the progressive triumph is so great in the United States that that's simply the accepted baseline. And knowing the history, that there was in fact a revolution, was obscured. And there was a time when people were doing these sort of things, talking about administrative state, where it really was just like a weird thing that a few younger conservatives were doing, that many others just simply were unaware of. Like the case you mentioned, I frequently brought to the students that there's an angry dissent in that case by Justice Roberts, who says, "What are we doing? This is a complete reversal of how judges have always done things. We're deferring to statute." But those people all died, and they really died, in a way that their voices don't have to get sort of picked up again. And it's really not until the 90s when I started hearing that sort of thing. And it was received as kind of weird in conservative intellectual circles.
We have multiple narratives of the conservative legal movement and its intellectual arc over the last 100 or so years. So you have a menu to choose from in the audience. Leigh, please.
I'm going to throw one more in, or maybe 2 more in. I think there was always I think there is some tension between, a couple of justifications for originalism and textualism. One of them is, we got to figure out what the law is, and the other is we want to minimize judicial discretion, and we want to respect the democratic branches. And those don't always point in the same direction. And I think that, to some extent, Scalia was sort of a believer in both of them, and but I think as, over time, he became more aware of the tension between the two and the need to choose. And I think that was one reason he was heading in the anti-Chevron direction by the time he died. I mean, it never quite made its way into an opinion, I think, but I do think that was going on with him and with, and I think with some other people as well. I think the other thing is there, related to what Eric said, but in a sort of milder form of it, it was a little bit of a dynamic thing where if you announce to agencies that they have this discretion, they may behave differently than before you announce to them that they have this discretion. And certainly my experiences when I was working in an agency and my experience on the Hill, was that awareness of that discretion was important. And it would lead you to be more adventurous in, the rules that you might write, because you kind of knew that you were going to get the benefit of the discretion and of the deference. Whereas, if you didn't know that, you might be a little more cautious about it. So, I do think there was kind of, and on the Hill, somewhat related to Ilan's point, yes, your first choice would be to have clear language doing what you wanted, but your second choice would be, well, if I can't get that, I'm going to go with the ambiguous language and hope that the agency will go my way, and write legislative history that will try to encourage that result. I think there's the congressional dysfunction problems and so on too. So I think that the congressional dysfunction coupled with the awareness that you might be able to badger the agency into doing what you want, leads to a more pathological system in some ways. So I think some of that as well. I guess that does lead me to an actual question, which is, does this kind of dynamic business affect how you think about whether the major question doctrine really is a plausible linguistic canon, as opposed to, perhaps a way of coping with some of this dysfunction?
I think that was to me, but since we're almost out of time, let's see if anyone has any final reactions, and I will take a stab at Lee's question. Yeah.
I make a quick comment that maybe they're talking to each other. We'll reply to both Leigh and Mark's.
We're answering your questions over there. That's very good.
Yeah. The agency aggressiveness, I think is a plausible theory, but I think it's not clear because Chevron was so arbitrarily applied that I think it didn't really give agencies enough guidance to kind of know when they could be aggressive and when they couldn't be. And I agree, Mark, with this idea that Chevron was successful in the sense that it promoted judicial restraint and legal realism. But again, I go back to the arbitrariness that I don't think it was, a success in that respect. I think the doctrine just ended up being so arbitrary. Agencies would win, but you would never know as in the appropriate circumstances and the not inappropriate circumstances, and it still depended on judicial ideology and the political party of the judges.
Tara, if you have any final thoughts?
I'll just say thank you, Leigh, for those thoughts. And I just want to reiterate, in the lower courts, Chevron was not nearly as messy as you're talking about. It was a disaster in the Supreme Court. Like, they were all over the map. But in the lower courts, I worked at the Department of Justice during the George W. Bush administration. Chevron was our friend, and we could rely on it, and I litigated in the courts of appeals. So I think the Barnett-Walker study really supports what I experienced as a lawyer. It was it was clear in ways that Eric would not like, but it was clear.
Yeah, being on the other side of the government doesn't feel as good. I'll be honest, you know, you're going in there and I lost a lot of cases. I lost a lot of cases, and it felt bad.
Just one anecdote. I got a question last fall. Did Chevron ever matter? I actually had a litigant say in their opposing brief to me, the statute's ambiguous, and I just smiled because we were going to win.
Well, we are a minute over, and we are standing between you and drinks, so I will use the opportunity to dodge Leigh's question and to thank you all for coming and to thank the panelists. Thank you.